So good afternoon, everyone. My name is Ellie Santoni, and I'm the Senior Director of Gift Planning at Montclair State University. And welcome to our webinar. I have the pleasure of having a volunteer and a friend of Montclair State University, Deirdre Wheatley-Liss, who has given her time to come and present to us today. And I just want to give a little bit of a brief background about Deirdre. She is the principal at Porzio Law Firm. She focuses her practice in the areas of asset protection, planning, taxation, estate planning and administration, and elder law for clients in the New York and New Jersey area. She holds a degree an LLM in taxation, which is an advanced legal degree. She's also accredited as a certified elder law attorney by the American Bar Association, approved by National Elder Law Foundation, one of the fewer than 50 attorneys in New Jersey with this credential. Deirdre is passionate about educating both the public and the legal community about issues relating to her areas of practice. She's the author of a published book, Plan Your Own Estate, and founder of PorsioPlanning.com, a resource for the public on estate planning, elder law, and estate administration. And before I hand it over to Deirdre, just a few housekeeping items. She will take questions as she goes along, and if we don't cover any of your questions, we will do that offline later. So it's my pleasure to introduce Deirdre.
Excellent, Ellie, thank you so much, and thank you everybody for attending today. If you're not familiar with Zoom, if you move, and Ellie, I'm actually going to spotlight myself, so as I'm doing this, one moment, there we go. Okay, so as you're doing this, if you're not familiar with Zoom, if you move your mouse around, there's a button that says Q&A. If you click on that, what you can do is you can actually type in questions, and as you have them, I'll see them when they come up, and I'll try to answer them as appropriate. Please do ask questions. It's hard enough when you're speaking to a live audience because you know what you're going to say, but you don't know what people are really thinking. It's really hard when you're staring at yourself in a video doing this, so any questions are appreciated. In terms of what we're going to be talking about today, what our agenda is the first is an estate plan checkup. Okay, everybody has an estate plan. A lot of things have changed though in 2020, not just with estate planning, but you know, our entire world, our outlook on the world has really been changed this year. So I want to talk about that. I then want to focus on the Secure Act. For many individuals, one of their largest assets for their family's net worth is their retirement account, and the Secure Act fundamentally changed how valuable a retirement account is for a beneficiary other than a spouse. And I want to make sure that you understand that and put in some sort of ideas of plans around that. And finally, I want to talk about planned giving, because I'm going to give you a little bit of, I'm going to spill some of the candy in the lobby. The Secure Act is the government grabbing money. Your family's getting less of your retirement plan. So is there a way through planned giving to potentially, instead of giving money away in taxes, look at having a shared arrangement with a charity that you then feel good about, your family's maximizing what it is that they have, and the government, well, they're not getting their taxes, but I'm a tax attorney, so that's not necessarily something that I cry over spilled milk. So with that, I want to start with an estate plan checkup. And why do you need to do an estate plan checkup? Your estate plan, whatever you have, represents a moment in time. You plan for who it is that you were then. I think that the best analogy of this is maybe a coat that you have had hanging in your closet for 15 years. If you put it on, would it keep you warm? Yeah, it'll do its job. However, is it of the style that you would do today? Potentially not. Alternatively, does it fit you the same way it did before? I don't know about you, but clothes of mine tend to magically shrink when they're in the closet for 15 years. So you need to look at your plan and make sure that it fits who you are today. And what I'm going to do is I'm going to spend the first part of our time that we have here today with what you need to do for the plan that you have in place to make sure that it's already working, it's still working for you. So what's the first thing that we do when we're looking at that? The first thing we have to consider is who is it that we're planning for? Because it's estate planning. You're not going to be here by definition. Are you concerned about protecting your spouse, your children, your grandchildren? Depending on your age, you may have financial responsibilities to your parents. Maybe you and your siblings jointly own family property. What about your fur babies? Who's going to take care of them, or how are they going to have the dollars to be able to do that? Maybe you're in a relationship with somebody that is not consummated as a marriage, but you have a joint economic relationship, a partner. How are you going to take care of them? Friends or your community. Are you looking to benefit your community as a whole? So the first thing that I recommend that you do is you put down a list of, if I were to get hit by a meteorite, who do I want to get my stuff? Not in detail, but just who do you consider to be your family? Who's the world that you're planning for right now? Okay. And then once you've done that, the next thing to do then is to look at your assets. Now, when it comes to looking at your assets, it's a question of doing a snapshot for today. What is it that you own? And when I say you, I mean anything that is in your name or anything that is in joint name with somebody else. Included in that is going to be personal property. I'm going to talk about that in a second, because personal property, when somebody passes away, can be the biggest headache. Vehicles, could be cars, boats, helicopters, whatever it is that you happen to own. Real estate, whether you own it in your own name, in joint name, maybe it's in an LLC. Bank accounts that you have, investment accounts that you have, retirement accounts. Life insurance. For insurance, we're looking at what is the death benefit of the insurance, because from an estate perspective, we're looking at what are the assets that you have when you pass away. Do you have a business? What kind of value is associated with that business? What about employee benefit plans? Is there an insurance policy available to you through your work, through your job? Is there some kind of benefit, a health benefit for your spouse, something along those lines? And digital assets, this new intangible stuff. So let me just point out a couple of these. Personal property. You may not give a lot of thought to it, but if you have more than one child, you potentially have an issue of who's going to end up getting what. Okay. If you only have one child, it may be that your child doesn't want anything. So what happens to your personal property? Give some thought to it. You know, what if you have a lovely family heirloom engagement ring and you have 3 daughters? Well, you can't divide a ring into 3 pieces. So how are you going to deal with that? I recently had a client who said that hers, she put in her documents, it was supposed to be sold. How are the children going to go through the things that you have, right? Do they go through and pick them order? Do they agree? Do your kids like each other? Do they like to agree with each other? Really give some thought to that, because this is the kind of stuff, and I'm not exaggerating here, why families no longer talk to each other. I had a family that I worked with. There were 3 brothers. There was a turkey platter that mom always served Thanksgiving turkey on. And I can't tell you the amount of just anger at each other about who was going to get the turkey platter. And I don't think a single one of these boys actually cooked. But it's the emotion that's tied to stuff. On the flip side, you may have a lot of stuff that you like, but your beneficiaries don't necessarily want it all. If that ends up being the case, you know, maybe it's a time to do a bit of a self-edit in terms of what it is that you have. In terms of your collections, maybe somebody can enjoy them now until waiting until you're not here anymore. So really give some thought and focus around that. If you own a business, as a business owner, you have 2 obligations. One obligation is to your family to make sure to maximize the value of the business. Are you doing that? Do you have a buy-sell agreement in place if you have a partner? Is there insurance in place if you don't have a partner to sort of replace your income? But on the flip side, you also have an obligation to your employees and your business partners. So should something happen to you or a business partner, do you have a plan for what would happen to the business? Literally, is there somebody who can cut the payroll checks next week? And really give some thought to how it is that needs to work and put a plan in place around that. And then finally, those digital assets. And that's probably one of the #1 reasons why you need to update your estate plan is you maybe didn't think about your digital assets. What are your digital assets? Your Facebook account, your Instagram account, your photos that are all uploaded somewhere, your library of Kindle or Audible downloads. We all have these digital assets now. And under the federal law, unless you have specifically given somebody the right to deal with your digital assets, your executor can't go to Google and say, I need access to their Gmail account because they passed away. Google's going to say, we're not allowed to give you access because something's called the Communication Decency Act actually prevents us from doing that. So in your documents, you have to have in there that if I have digital assets, that somebody has the authority to really do things with them. And again, as I'm going through here, I'm staying at a relatively high level, but please, if you have any questions, ask them. So now we know who your family is. Now you have a list of what your assets are, okay? Look at your existing documents. Is your estate plan complete? In order for your estate plan to be complete, it must have at a minimum 3 documents. A last will and testament. This is what says, here's who gets my stuff when I pass away. A general durable power of attorney. This is answering the question, who can make financial decisions for me if I cannot make them for myself? And then finally, a healthcare power of attorney and living will. This is who can make medical decisions for me if I can't make them for myself. Now, I'm going to pause on those a few minutes. Your will only controls the assets that are in your name when you pass away. So if I flip back to the prior screen, your will is not going to control your retirement accounts, and it's not going to control your insurance because those have beneficiary designations. And those assets are going to go to the named beneficiaries regardless of what your will says. Looking on the other side, real estate. Maybe you own real estate jointly with somebody. That joint asset is going to go to the owner of the joint asset and not go through your will. Now, sometimes when I talk about that, people ask me, well, shouldn't all of my assets either be in joint name or have beneficiary designations to avoid probate? In a state other than New Jersey, potentially, probate in New Jersey is so easy. It's you wait 10 days, you go to the surrogate's court, you offer them the will, you give them some information about who the beneficiaries are. They send you something called letters testamentary that says that this person's the executor of the estate, and probate's done. The court isn't overseeing how your executor is acting. It's not a formal probate process like it is in other states. Florida and California in particular come to mind, so does New York. So because of that, you don't necessarily need to avoid probate. And if you want to avoid probate, a revocable trust, which is something that I'll be talking about in a moment, is a much more effective way of avoiding probate than naming beneficiaries. So I just want to give you one example. I had a client, she had 6 grandchildren. She created 6 CDs. They each started with $100,000, okay? And that was great until she got sick. When she got sick, her power of attorney needed to start spending down those CDs for her care. Well, the power of attorney didn't pull $1,000 from each of the 6 CDs every time she needed $6,000. She eliminated one, she eliminated the other, and then she eliminated part of a third. Well, now what ended up happening? 3 of the beneficiaries still had their CDs for $100,000. One beneficiary had a CD for $50,000 and 2 beneficiaries got nothing. That was not what the person's intentions were. A will makes sure that your intentions are in fact actually carried out. I'm just going to pause here a second. So the question is, can your estate be the beneficiary of your retirement account? And the answer is yes, but you don't want it to do so. And actually, that's a great lead into what we're talking about in the second half, which is retirement accounts. But just to answer from a top level right now, an estate, if you leave your retirement account to your estate must withdraw the money from your retirement account more quickly than either a human being, my daughter, my son has to withdraw it, or alternatively, a trust that's created for a human being. So with that, I'm just going to put that on pause until we're able to come back to it later. So I mentioned a revocable trust there for a second. The idea with a revocable trust is that in states where there is this high cost of probate, a formal probate, a revocable trust, if it owns your assets, doesn't pass away. But because it's revocable, you're the grantor, you're the trustee, so you're the president of the trust, you're in charge, you're the beneficiary, you pay all the taxes. It's as if the trust doesn't exist during your lifetime. But when you pass away, since the trust owns some of your assets, those assets don't go through probate because the trust didn't pass away, you passed away. So it's very common in states with a high cost of probate, which sometimes if you see a commentator on TV, a financial commentator, and like, you must have a revocable trust, just give some thought to what state they're coming from, because while that may make sense in California, it doesn't always make sense in New Jersey. Now, does that mean I don't use revocable trust? No. It means that I use them as a tool when it's appropriate for a specific client, not as sort of, it doesn't necessarily have to be the default planning. And I say this only because if I'm drafting a trust in addition to a will, a power of attorney, healthcare power, it's going to be more expensive. I want to contrast that with an irrevocable trust, which I'll go into in a minute. Before I turn over, we actually have a question about permission to access digital accounts. How does that work? There's something called the, it's called the RUFADA. Yeah, that's actually, well, it's not a word, it's an acronym. We attorneys love acronyms. It's the Uniform Digital Property Act. And with the Uniform Digital Property Act, it says that in writing, you can give somebody else the ability to access your accounts. Now, remember, if you don't do this, nobody will be able to access your accounts. So what we do is we put language regarding that first in your will, so your executor can access your accounts, and then also in your power of attorney, so your power of attorney can access your accounts. Now, this does not have to be an all or nothing. If you maybe have an account that you don't want anybody to see, that doesn't have to be, you can say you can access my email accounts, but you can't access anything else. And that's what really allows somebody else to have control of your digital assets after you pass away. So looking at this, one more question, I apologize, I want to read it to make sure that I understand that. A person, a beneficiary of the account supersedes the will. Yes. So as I said before, what ends up happening is that your will only controls your probate assets. If you have an asset that has a beneficiary, it goes to the beneficiary. It does not go to your will. If I say in my will, I leave my life insurance policy to my son, but my life insurance policy says I leave it to my mother, it doesn't matter what my will says. The life insurance policy is going to my mother. So you need to make sure that when you're looking at your overall plan, this is why you need to look at your finances and do a list of them. For those assets that have beneficiaries, are they coordinated with your estate plan? So let's say you have young children, you have children under the age of 18, and with those children that are under the age of 18, you have a trust that's set up for them, okay? And your entire estate consists of a retirement account and a life insurance, okay? You pass away. Your retirement account names your child, who's a minor, as a beneficiary. Your life insurance names your child, who's a minor, as a beneficiary. It doesn't matter what your will says. Those assets are going to the minor child, and I'm really going to frighten you here, and that child's going to get control of them when they turn 18. At this moment in time, I have an 18-year-old. I would not recommend turning copious amounts of dollars over to him, not because he's not very intelligent. He is. He just doesn't have a lot of life experience because he's 18 years old. So with that, I'm going to flip to our next slide here, which is your estate plan current? So as I mentioned at the top, your estate plan is like that jacket that's been sitting in your closet. Functional, but does it really work? Have you moved? Maybe your jacket analogy is you have a ski jacket and well, you live in Florida now, okay? The same way that you would change your wardrobe, you need to have your estate plan looked at by local counsel. Is it more than 5 to 10 years old? Tax laws change, your beneficiaries change, your life changes. You really should be revisiting your estate plan once every 5 to 10 years. And in New Jersey, if you have a power of attorney that names somebody other than your spouse, if it's more than 10 years old, banking institutions are not required to accept it. So you definitely want to have those updated and refreshed. Have you gotten married or divorced? It gets very messy in this situation. As soon as you get married, your new spouse has rights to your assets. Okay. They have a right to 1/3 of your estate. If you get divorced, your divorce ends certain assets that your spouse has, but not all of them. So as an example, if you get divorced and you have a 401k plan and you never get around to changing your spouse as your now ex-spouse as the beneficiary, your ex-spouse is going to get those dollars regardless of what your will says. And even though you're not here, you're probably not going to be particularly happy because if you divorce the person, you probably don't want them to get your 401k account. Have you changed change jobs. The reason that that's important is because a lot of value to your estate could come out of those employee benefit plans. And when you start a new job, you get a stack of forms that's this high to sign. Going back to my example, are your beneficiaries correct on your employer provided life insurance, your employer provided benefits? Because if it goes to your child, but your child's a minor or too young to manage it, it's probably not meeting your intentions. Again, have your family changed, and then has your fiduciary changed? And I'll go over that a little bit in detail. I do talk a lot about trust, so I just want to take a pause here and explain what trusts are. Think of a trust like a mini family business. So the best example that comes to mind is think of the local pizzeria that was kindly feeding you for the past 6 months when you weren't able to go out to restaurants at all, okay? It's owned by a family. There was somebody who created it. That's the grantor in the idea of being a trust. There is a president of the entity. That's the trustee in trust language. And then there's the family that benefits from the dollars. Those are the beneficiaries. And just like a business, a trust can own any asset. It could own real estate, cash, investments accounts, stocks, bonds, whatever the case may be. The benefit of a trust is when you leave a trust to somebody else. I leave my assets to you, my spouse, in trust. I leave my assets to you, my child, in trust. You, my spouse or child, can even be the trustee. You can be the president of your own money. When you leave assets in a trust for another person, those assets are exempt from the beneficiary's creditors. So what do I mean by that? I leave assets in a trust for my son. My son starts his own business. It's going gangbusters, and then there's a global pandemic. He took out loans to start the business. He doesn't have the assets to pay them back, but he has this trust. The trust cannot be used to satisfy his debts. My son, again, he gets a job. He's 20-something years old, and he gets the cheapest possible health insurance, and then unfortunately he gets sick. There's big medical bills associated with that. If the money is in the trust, those medical bills can't be used to satisfy it. And the most important one is my son gets married, and unfortunately the relationship doesn't work out and he gets divorced. The assets in the trust are not on the table to be divided in the event of a divorce. If there is one thing that you take away from here today, look at your plan. Trust are amazing tools. No matter how much you're leaving to your family, it is new money to them that you want to go to them and not to anybody else. Consider having it be in a trust for them instead of going outright to them. And if you think that your kids and your family members are wonderful people and they can manage their own money, make them the trustee of the trust, but give them that protection because they can't do it for themselves. It is a gift that you can give to them within your estate plan. All right. So I promised that I would talk about who it is that a person's fiduciaries are. So in terms of who the fiduciaries are, these are the people that carry out your plan. This is the linchpin to your plan because all I'm doing is I'm writing things on a piece of paper. It's black and white. It makes a heck of a lot of sense to me because I'm an attorney and I'm the one who wrote it. But if you've read your will at all recently, the language is horrendous. I mean, this is estate law is very, very old law, and we took it over from England, but in England even, it really came out of when Henry VIII was running into some monetary problems. You might recall he kept getting divorced and, beheading his wives. He was running into some monetary problems, and he did a lot of changes to how property law worked in England in terms of who inherited things when the nobles who owned all the property passed away. That's old law, okay? I'm going back to the 1600s here, 1400s even. So as a result of that, when you read the documents, they don't necessarily say this is exactly what I want to have happen. They give intentions, they give parameters, and they talk in legalese. The person who's in charge of carrying that out, that's the person who's then going to allow your documents to come to life. That's how your values get passed along with your documents. By having somebody who's making the decisions that you would make, who's dividing up your personal property the way that you would divide it, who, when a beneficiary says to them, I absolutely positively must have a Lamborghini or my life is going to end, is going to say, you know what? I would be happy to help you create a savings plan for your Lamborghini, but that's really not what your parents would have wanted the trust to be used for. If you want to maybe talk about getting some kind of Honda SUV, we can have a discussion around that, okay? Your executor is a short-term job. All they do is carry out your will until the assets go to the beneficiaries, which could be a trust for the beneficiaries. As I mentioned before, the trustee is the president of the trust. The trustee is the person who is the long-term job of meeting with the beneficiaries on a regular basis, finding out what their needs are, meeting with the investment advisor to say, how are we going to invest the assets in these trusts to be able to meet these needs, and then making distributions to the beneficiaries as appropriate. When I say it's a long-term job, it is a job. You need to consider your trustee very, very carefully. I encourage people to think about who's going to act in these roles, okay? You have 3 children, you have a son, and you have 2 daughters. Your son happens to be the oldest, okay? Your son has an incredibly successful business out on the West Coast, and you live here on the East Coast. Your knee-jerk reaction might be, well, I'm going to name my son because he's the oldest, okay? But let's say that your middle daughter lives a town over from you and is a CPA, and your youngest daughter lives 2 towns over and she's a nurse, okay? Maybe those that are here and are more familiar with your finances because they're helping you out with things are a better person to name. Or maybe your kids don't really get along with each other and you say, you know what? I'm going to name my friend to do this. I'm going to name my accountant, my attorney, whatever the case is. Really give some thought. We all know that family and money don't mix. Take a pause, give some thought. If your family and money don't mix, find somebody else to be the executor or the trustee that's not a beneficiary, because you want your family to continue to get together for Thanksgiving. That's what the goal is. Your guardian. If you have children that are under the age of 18, you're naming somebody to look out for them, to care for them. Again, give a lot of thought to who it is that this person should be. Sometimes people say, well, my parents are going to be the guardians. Well, if you have, you know, a 14-year-old and a 12-year-old and your parents are, you know, in their late 70s and have health issues, does that really make sense? Or you say, well, I named my sister, but again, your sister lives across the country. Maybe when they're older, because you want them to finish up in the school system, you name a really close friend as the guardian and your sister as the trustee. So just some thoughts to give to that. Attorney in fact, you're still alive. You don't have capacity. This person makes financial decisions for you. Healthcare representative, same scenario, person's making medical decisions for you. And then successors. What happens if you and the person that was named get hit by a meteorite? Somebody else needs to act in that particular situation. One of the questions I got here is, can the executor and the trustee be the same person? They absolutely can be. So for some families, when I describe this, they're like, you know what? My sister Shania, she's going to be the single best person to do this. Okay. You know, she's the one who immediately viscerally comes to mind, and she should act in all roles. She's very close to our family and she's the right person. Right. Then I have other families, and maybe they're going to say, well, we want Lee to act in this role, but you know, Lee, she's really, really good with money, but she's not as close to our children. So maybe we're going to have Stacy act as the guardian, Lee act as the trustee, and then the 2 of them work together. So there can be a single person in the role, but remember, particularly when your kids are younger, there's no checks and balances looking out for them. There's no court that they're you know, reporting to. There's no third party. So really give some thought to maybe creating your own checks and balances by maybe having the guardian and the trustee be co-trustees, and then one person is the guardian. So just sort of a thought around that. So when you're doing your will checkup, practical questions. Do you know where the originals are? Do you have copies? You need to have the answer to this. If you don't know where the originals are, contact the attorney who drafted them. They probably have the originals and you have copies. If you think you have the originals, please actually look at them. You may actually just have copies. This is important because when somebody dies, we need the original document. So you need to know where it is. Has your will been updated for tax planning? Up until 2018, New Jersey had an estate tax. Since 2018, New Jersey does not have an estate tax. Your documents might have been created for an estate tax that doesn't exist anymore, in which case it might not make sense right now. So you need to look at that. Specific bequests. Specific bequests are, I give $5,000 to this person, $10,000 to Montclair State University. I give my diamond engagement ring to this person. I give my shore house to that person. Are the people, if you give them to people, still alive? If the people weren't there, Does the bequest lapse, as in it doesn't get made, or should it go to their beneficiaries? If you don't say, it's going to go to their beneficiaries. But if you gave $10,000 to a niece, you may have a relationship with her, but not really know her children at all. So that isn't really what your intentions are. The same thing goes for a specific piece of property. I leave a piece of property to my brother. If I don't own the property when I die, does my brother get nothing? Does he get the value of the property? What ends up happening? Pets. I want to pause here. I am a pet owner. Many people are, because I know the shelters were literally running out of pets because everybody's been working from home. You got to give some thought to your fur babies, okay? First of all, who's going to take care of them? You should have a conversation with somebody about that. Secondly, are you going to compensate that person? Because there's vet bills and there's food and everything else that comes along with it. Candidly, I do have clients that are far more interested in what happens to their pets than it is that happens to other people. Let's say you don't have anybody to care for your pets and you potentially have long-lived pets. You have a parrot or a horse or a tortoise. There are charitable institutions that will provide for your pet. These are people who love that particular kind of animal. And you arrange with them that they'll take care of your pet in this situation that you want them to be, and then you arrange to give them a donation in return for that. So really think about your pets. Trust distribution terms. Read them. If you don't understand them, call the attorney and say, I need you to tell me in English what this says. Let me give you an example. My daughter Sarah, she needs money for college. Is that paid for? Okay, great. She needs money for a house. How would that work? She wants to start a business, but it's a horrible business plan idea. What ends up happening there? She's getting a lot of pressure from her spouse and to be able to take money out of the trust, and her spouse doesn't necessarily think in her best interest. What happens there? Whatever those situations are, kick that through with the attorney so you understand if the trust really works the way you want it to. And then finally, as I said, look at who your executor, your guardian, and your trustee are. Okay. I talked a lot about already your non-probate assets, the things that don't pass through the will. If it's joint, do you really intend the money to go to the joint owner? The example with this is what I'm going to call convenience accounts. Mom likes to have a lot of cash in her checking account because it makes her really, really happy. Mom has 5 children. Mom's son, Samuel, is the one who lives closest and helps her with the finances. Mom says, hey, well, I'm just going to put Samuel. It's not even mom. Let me step back there. Mom and Samuel go to the bank, and Samuel says, I need to be able to write checks on mom's account. And the teller goes, it'd be a really good idea to make this a joint account. And mom says, that sounds great. Can you write checks on a joint account? The teller says, yes. Awesome. Great. Here's the result of the joint account, though. We talked about it before. When mom dies, Sam's getting 100% of the joint account. That may not have been mom's intention with these $60,000. So if there's a joint account, if you get hit by a meteorite, is the intention that all of that money goes to the other person? If it's not, and the only reason the person's on the account, what you can do is go to the bank and have the person become a power of attorney over that account at the bank. That's paperwork at the bank, and then they can sign checks if that's what your intention is. Secondarily, as I mentioned before, if you create the world's most beautiful trust within your will, and you have retirement plan assets that go to a person and not to the trust, then your beautiful trust will never be funded, and everything, the reasons why you created it, will not actually be carried out. So you need to coordinate the beneficiary designations, that's usually retirement plans and life insurance, with your estate plan in terms of what it is that you have. All right. Power of attorney. So here's your checkup items and your power of attorney. Does it say the word durable in there somewhere? The actual word, not some kind of, synonym for the word durable, the actual word durable. What that means is that the power of attorney continues to be effective should you become incapacitated. Now you may be saying to yourself, Deirdre, that makes absolutely no sense. I don't want a power of attorney unless I become incapacitated. Well, I agree with you. But under the law, if you create a power of attorney and it's not durable, then as soon as you become incapacitated, it becomes ineffective. So it has to say the word durable. Secondly, does your power of attorney have gifting powers? Does it allow your attorney, in fact, to transfer assets to somebody else? And you may say to me, well, no, it doesn't. I don't want them to do that. But let's say that you're older, and let's say that you get sick, and now you're starting to spend $15,000 a month on your health care. You may want to transfer some of those assets so that you reduce the amount of assets that you are forced to spend on long-term care. If you do not have gifting powers in there, then there's no opportunity to do that. On the flip side, if you have gifting powers in there and who am I going to pick on this time? Timothy. Timothy is your power of attorney, and Timothy lost his job, and Timothy moved in with you, and Timothy decided that I need all of mom's money. My other siblings are fine, and transferred everything to his own name because there's a gifting power. That doesn't make sense either. So sometimes we'll put in there that gifts can be made, but only if a third party reviews the situation, an attorney, accountant, another family member, a friend, something like that. With your attorney, in fact, do you still have a good relationship with that person? If you don't, somebody else should be named. And then finally, is your power of attorney notarized? If it is not notarized, it cannot be used to transfer real estate. So you need to make sure that it was actually properly executed. Okay. So the next document, healthcare power of attorney. Do you have a living will? What's a living will, you may ask? I managed to go in the wrong direction. Hold on one second. With the living will is a question of what kind of decisions do I want somebody to make for me if I am in a terminal medical situation? I do note that I am doing this lecture right now during the COVID pandemic. A lot of the language that we have always had in our living wills deals with not wishing to have mechanical respiration. That made a lot of sense pre-COVID. You might want to take a look at it now and see if that still makes sense for you for in the event that you were to contract COVID and need that kind of care to potentially recover from COVID. Same thing, who's your healthcare representative? Do you still like them? Who's the successor? A HIPAA authorization. A HIPAA authorization allows your healthcare representative to see your medical information. If you don't see, literally it says in there, the Health Insurance Portability Act of 1996 in there, that you need to make sure to have that document updated, okay? Just because I mentioned with the pandemic, there was a question here, and actually it's a statement. I expect estate taxes to rise significantly and perhaps reappear in New Jersey post-pandemic. So I have to tell you, I potentially agree with you. So I'm just going to take a pause here, well, because it's my seminar, and because I don't have an audience, I get to sort of chat away. Here's the situation that we're facing, okay? And remember, I'm a tax attorney, so tax policy is something that not only that I've studied, but I'm actually really, really interested in, okay? This is not about politics at all right? The federal government in 2020 thus far, and I'm doing this in September, has spent an unbudgeted $3 trillion, okay? That is an unbelievably massive amount of money. There is only one way that the federal government is able to have revenue, and that is through tax revenue, okay? At some point in time, there is going to have to be more dollars coming in. I actually saw an article, I'm going to say it was about 2 weeks ago, that our amount of debt right now is at approximately 96% of what our annual budget is. Now, I don't know how you all run your household, but you can't have your debt be more than what it is that you are able to take in every year. That just doesn't work at all. So there's going to have to be some kind of reckoning. From the New Jersey perspective, in New Jersey, we've only spent billions, not trillions, of unbudgeted dollars. New Jersey still has an estate tax on the books. So when New Jersey eliminated the estate tax in 2018, they didn't cross out the statute. All they did is they said, we still have an estate tax, but instead of the tax rate being 16%, we're going to drop it to 0%, okay? I would suggest to you that it's very easy for them to go back in with the legislative pen, take that 0 and put it back up to another number. Will the estate tax reappear? I don't know. The issue that we have here in New Jersey is that we have incredibly high income taxes. So particularly when people retire or if people are looking to sell their businesses, that's when they start looking at other states, or if people are looking to start businesses and they need to employ people somewhere, they start to look at other states and say, hey, if I was making the same $100,000 a year in Florida, I wouldn't have to kick over, $6,500 to the state of New Jersey for what it is that I'm doing. So that's why people look at moving out of New Jersey. Do they move out of New Jersey because of the estate tax versus out of the income tax? In my own experience, I've never had a person move out of New Jersey solely because of the estate tax, but absolutely people have moved because of the income tax. Regardless, the solution's going to be painful, folks. And I only say that because we spent this amount of money, and I know that taxes are the only way to give revenue. So with that, and again, I'm not being political, but just taxes may change in the future. What happens if you have minor children? Well, you got to have guardians in your will. You can also in New Jersey appoint a temporary guardian. Again, very important in this COVID era. You're a single parent. What happens if you get sick and your 7-year-old is at home alone? Just because your neighbor always takes care of your 7-year-old after school does not mean that a police officer, if you unexpectedly become ill and are taken off to the hospital, is allowed to leave your 7-year-old child with your neighbor. In that situation, they would actually be taken into protective custody. You don't want that to happen. Create a temporary standby guardianship that says that if I am incapacitated or I unexpectedly pass away, my neighbor is the immediate guardian. They may not be my long-term guardian, but they're the one that are going to be taking care of it. And then also looking at trusts for your children. We talked a lot about that. I really think it's one of the greatest gifts that you can give your kids. On the flip side of the spectrum, you're concerned about long-term care costs, okay? There's only 4 ways to pay for long-term care costs. There's Medicare. Medicare does not pay for if you need assistance with activities of daily living. It pays for health and hospitalization. So if you have Alzheimer's, they'll pay for your Alzheimer's medication. If because of Alzheimer's, you need help getting dressed in the morning, they do not pay for that. Private pay pays for that, but it's expensive. In New Jersey, if you're looking at assisted living, minimum $6,500 a month. If you're looking at a nursing home, more like $12,000 a month. You could have long-term care insurance that pays for it, but unfortunately, I think less than 12% of the population has long-term care insurance, and the rest is Medicaid. Medicaid will cover long-term care costs, but unlike Medicare, you have to financially qualify for it. That's where asset protection planning comes into play. So sometimes as people get older, they say, my estate planning isn't as relevant to me. I don't have a taxable estate. The federal exemption is $11 million right now, but I'm really concerned about long-term care costs. Asset protection planning is planning during your lifetime to minimize the amount of assets that are actually exposed to long-term care costs. All right. Practical questions as you do an estate plan checkup. One practical question as you do an estate plan checkup is to look at that list of assets and liabilities that you did. Does somebody else know where it is? It's a little challenging to administer somebody's estate when we have no idea what their assets are. I literally will get copies of tax returns to go through to try to figure out that if you had income from Bank of America, therefore you must have an account at Bank of America. It's a little bit like doing, an old-fashioned Columbo Detective Act. It's a lot easier if you have a list of your assets. A list of your advisors. If something were to happen to you, does your daughter know who your attorney is, who your accountant, your financial advisor, your insurance advisor? Contact information for fiduciaries. If I'm helping your daughter with your estate and you've named your friend who lives in Hawaii as the fiduciary, is their address potentially in there, or do we need to try to figure out where they are? Passwords, all right? So many of our assets are locked behind passwords online these days, okay? So let's say that I'm going to be really, I'll use me as an example. My husband does all the banking in our house, okay? I don't touch it. It's not what I do. It's not my job within our household, which means he's got all the passports. Well, if my husband gets hit by a bus, I still don't have any of these passwords. And I don't even think we get mail on some of them anymore. It's all electronic, right? Well, I don't want my husband to write down all the passwords because I don't want somebody breaking into our house and having a list of all the passwords to our bank accounts. That doesn't really make a lot of sense. I strongly suggest for your digital assets that you look into getting a password manager, something like Dashlane, in which case you only remember one password, and then it automatically assigns these incredibly encrypted passwords, which like characters you didn't realize that were on the keyboard that are like 12, 14 characters long to each account, with the idea that A, you don't have to remember it, B, it's really, really secure, and C, if it does actually end up getting hacked, you have a different password for every account. So something to look at. And then finally, your key documents. Wherever you store them, make sure that somebody else knows. I know some people like to keep them in a drawer. Some people, I've had them keep them in a black bag up in the attic. I don't care where you keep your documents, but it is really super important that if you do have documents that somebody knows where they are. So, look, it's in the third drawer down in the dining room, fine. Make sure that your kids or your neighbor or your best friend actually know where it is that your documents are. Okay. Valuable conversations. We are talking here money, assets. That's really not so important when it comes to inheritance. Your family values, your memories, that's what's important. Making sure that you're cared for the way you want to. If you have end of life wishes, look, it's going to happen to all of us. Think about them. You know, I've got a client of mine. She has instructions for the kinds of butterflies she wants released at her memorial. Awesome, great, fine. I'll make sure that it happens. Family love letter. This is what's important to me, family. It's important to me that you get an education. It's important to me that you engage in community service. It's important to me that you're philanthropic, right? It's important to me that you practice gratitude, travel the world, learn how to cook, ride a horse. I don't care what it is, but if it's important to you, a family love letter is something that you just sort of write down every year. Here's what my wishes are for you, and it goes with your estate plan, and maybe you update it once a year. For trustees and guardians, here's what I want you to do on my behalf. No to the Lamborghini, yes to the Pathfinder. It's important to me that they start a business, but if so, they need to have a really solid business plan, and that you loan the money to them, don't just give the money to them. Those are some ideas with that. So with this and the rest of the time here, I want to talk a little bit about the Secure Act, how it negatively impacts the value of your retirement account from an inheritance standpoint, and what you can do about it, okay? So the Secure Act became effective January 1st of this year. Bottom line, it accelerates the income taxation on retirement accounts inherited by a non-spouse, okay? When you take money out of a retirement account, it hasn't been taxed yet, it's taxed at the time that you take it out. It used to be that a beneficiary, my mother leaves her retirement account to me, I could take it out over my lifetime. And depending on my age, that could be 30 or 40 or even 50 or 60 years. Now it all has to be taken out in 10 years because every distribution is subject to income tax. This is a gigantic tax grab for retirement accounts. Now, from a policy perspective, this might make sense because they're called retirement accounts. And if you're deceased, you no longer need to support yourself in your retirement. But having said that, the value on paper of that account to you is significantly less that goes in the pocket of your beneficiary because of taxes. And I want to talk about how that's going to work. Under the new law, any retirement account going to somebody other than a spouse, a minor child, or a disabled individual must be withdrawn within 10 years. Now, you don't have to take those required minimum distributions. You don't have to take a little every year, but you do got to take the entire thing within 10 years. You used to be able to stretch it out over your lifetime. The problem with this is that it accelerates income taxation, and if it's not being distributed to a trust, it's now in the person's name. So remember all those bad things I said could happen? Well, now they could happen with what is potentially one of your largest assets. So let's look at this in a little bit more detail, okay? So I don't do math in my head. I was a humanities major. I was not a STEM person. So let's look at the math here. Before the Secure Act, I'm 45 years old. My father passes away. I inherited an IRA with $1 million. I'm only using that because that is math that is easier to do, okay? At that point, I would have had a life expectancy of 38.8 years. Under the old rules, the first year I had to take out 1/38, the next year 1/37, the year after 1/36, so on and so forth. I have the required minimum distribution I have to take out each year, but remember, IRAs grow tax-free. If you haven't taken the money out, everything that's in an IRA or retirement account, the growth on it is not subject to income tax every year. So at the end of 10 years of my very basic, simplistic, overly assumed calculations, I still got $1.5 million, even though I've taken out all this money every year, okay? Well, now let's look at the Secure Act math, all right? I inherit $1 million and I decide I'm gonna take out $100,000 a year to help support my lifestyle, okay? Same $1 million, but every time I take money out, I gotta pay taxes on it. So with the example that I have here, I'm assuming that the person's in a 25% federal tax bracket, and they're here in New Jersey at 6.35%, which means every time I take out $100,000, I'm only getting $68,650, okay? Because I gotta pay taxes on everything. But look what happens in year 10. In year 10, I've got to take the entire thing out, $626,000. See that asterisk on the federal tax rate at 25%? If I have income of $626,000, I am no longer in the 25% tax bracket. I am now in the 37% tax bracket. So because of the fact that I have to take out so much money in a given year, I'm actually popping myself up 3 tax brackets for where the taxation is. So of that $626,000, I'm only getting $351,000, which means at the end of the day, I'm only inheriting of the $1 million tax-free that I deferred taking out over 10 years, I'm only putting a little bit more than that same $1 million in my pocket because of all the taxes, okay? So sometimes I go through this and people say to me, well, great, I'll take all the money out in year 10. Well, that doesn't necessarily improve your situation as dramatically as you might think. So here's an example where I don't take any money out until year 10 because I don't have to. But in year 10, I got to take out, in this example, $2 million. Now, every single penny of this is going to be taxed at that 37% tax rate, assuming that I've got other income that's going to bring me up to that. And now my federal tax is, almost $800,000. My New Jersey tax is $133,000. And the balance that's going in my pocket is $1.1 million. Now, that's more than the example before, but it's still not the same $1.5 million I would have gotten over that same 10-year period, the asset I would have had over that same 10-year period if that hadn't happened, if there wasn't the Secure Act, okay? So how do we deal with this? And this is sort of the takeaway of what you can do to make that retirement plan more valuable for you on a going forward basis. One thing you can do is you can replace the assets with life insurance. You may already have life insurance. Maybe you got life insurance because there were estate taxes. Well, look at the loss to the account. I'm just going to go back to the last one. Look at the loss to the account as a result of being forced to take the money out, and you can potentially replace that with life insurance. That's one thing to do. Well, you may not have life insurance. You may not want to get life insurance. You may not believe in life insurance. So what's another alternative? This is the idea that I want to leave you with. Reinventing that stretch IRA that I only take out a little bit every year, so there's a lot that's available to me, with something called a charitable remainder trust. A charitable remainder trust is what we call a split interest trust. So if you look at sort of the illustration that I have here, I've got $1 million in the IRA. I contribute $1 million to a charitable remainder trust. Why is that important? Charities don't pay income taxes. So where my beneficiary only would have received a fraction of the $1 million, they'd taken it all out in the first year, the charity receives actually $1 million. The charitable remainder trust receives $1 million. The trust is then set up that to my child, to the beneficiary, I give them a certain amount of money for their lifetime. I can give them a % of the money. I can give them a fixed sum of money. It depends on how it is that you design it. And at the end of the day, whatever's left over goes to a charity. Now, Montclair State University is very kindly sponsoring this talk today, so I'm going to use them in this example. You have $1 million IRA, you put into a charitable remainder trust, you name Montclair State University as the remainder beneficiary at the end of, let's call it a 10-year term. And for those 10 years or for up to 20 years, the child gets the money during that period of time. Okay, so let's look at what that looks like. Okay, we start with our same $1 million of principal that we had originally. We're still having growth at 7%. We're not paying any taxes on anything, so that's great. In this example here, I illustrated it over a 10-year time frame. So over a 10-year time frame, and I did it that the person would be getting a % of the value of the trust each year. So in the first year, they get $205,000, and that starts to go down because as they're taking out distributions, the amount of principal goes down. Now, the way that these numbers work is very specific to how it is that this is being structured. It's specific to what interest rates are at the time that you set it up. So this is a very overall illustration here, okay? But you can see here that I put $1 million of principal into my charitable remainder trust, and the distributions to my child as the beneficiary were $1.1 million. You're like, okay, well, that's still not that $1.5 million that we were talking about under the old law. I get that. There is not from the charity. So if you look at the first 1, 2, 3, 4, 5 columns, the government's not a beneficiary of that at all. At the end of the day, the charity, in this case, I'm going to use again the example of Montclair State, is going to receive $204,000. If we ended the analysis there, so forget the 2 columns that are on the far right, if we end the analysis there, my beneficiary is getting around the same amount of money as if they did the $100,000 a year that we talked about them taking out. The government is getting 0, and the institution that gave me my education is getting a little north of $200,000. Now, some people feel really good about this because since the government's getting no money here, they're happy. But the beneficiary is actually getting a little bit more than 1.1 million, okay? So let's say that the beneficiary, they receive the distribution. they're going to have to pay taxes on the distribution, but not on 100% of the distribution. It's way too complicated for me to go into on this conversation, but you're going to see here I illustrated it at 15%. So when the beneficiary gets money from the charitable remainder trust, they have some income tax, but it's not 100% income taxable like it was where they were getting it directly from the IRA. So let's say that my beneficiary is the saver, and now they put that money and they now invest that money, and they invested and they get 7%, but I illustrated a rate of return here of 4.5% because they have to pay taxes because it's not in an IRA or it's not in the charitable remainder trust anymore. But at the end of 10 years, under this sort of assumption that I've put together, now my beneficiary has got $1.4 million. A lot closer to what the scenario was when we had the Stretch IRA, which was eliminated with the Secure Act. And again, here, you know, the amount of money that's going to the government is way less. So if that's something that excites you, this is an idea for something that you're able to do. So at the close here, and I'm going to ask, and I'll take a pause. If you have any last questions, this is the time to type them in and see, you know, what they are. And I'm happy to ask them if you have questions after the fact. As Ellie said at the top, she'll be able to, you know, get those questions answered. But another resource for you is Porzio Planning. So Porzio Planning is a website that we've designed that specifically caters to questions that individuals have about estate planning, elder law, estate administration because somebody passed away, estate or trust litigation because the trustee isn't doing the right thing or whatever the case may be, dealing with special needs if you have adult disabled children, as well as guardianship issues, particularly as loved ones age and potentially there's change in their mental acuity at that point in time. We have lots of blog resources, videos, we do monthly webinars, that, you know, that talk about the things that are very similar to what we talked about today. So if you do have questions and you're looking for a resource, I suggest sharing it with you. If you're looking for another resource, as I said at the top, take your estate planning documents, go back to your attorney, make sure your attorney should take a phone call from you and say, you know, be able to say, here's what it is that we're going to be putting together. And, you know, this is what we're doing. So I did get a question about costs, and costs vary depending on what your needs are. What a lot of attorneys will do is for certain types of planning, they'll do it on what's called a flat fee basis. I need to have a will, a power of attorney done, a revocable trust. That's going to cost you X dollars. I need to have an asset protection plan put together. That's going to cost you Y dollars. There's other things that are done on an hourly basis. The one that most readily comes to mind is dealing with an estate administration, simply because an estate administration is like a Pandora's box. We literally have no idea what we're getting into until you open it up and you see what's there. But it's a fair question to ask any attorney that you're looking to have represent you. You should absolutely expect to get an engagement agreement in writing that clearly states how these services are going to be paid for, whether it's a flat fee or hourly or a combination. So as an example, we might say we will prepare a trust agreement for you for X, but we are going to bill hourly at a paralegal rate for the funding, for putting assets into the trust, as an example. So it's a very important question, and you should be clear on exactly what it is that you're getting from your attorney. Now, having said that, and this is just our practice, because we do a lot of this work on a flat fee basis, when a client does call us up 3 years later and say, I just read through my estate planning documents, and honestly, Deirdre, I remember what we said at the time, but I have no idea what this means today. We get on the phone with them, you know, it's like 15 minutes and say, here's what the documents say, you know, this makes sense. Do you want any changes? Yes, I want changes. If there's changes, usually there's another fee that's associated with that. Or it's just, it was great to reconnect with you because we really like to talk about estate planning. We're happy to make sure that you understand what it is that your documents say. So with that, Ellie, if you want to come back online, I'll take the spotlight off so that you can come back online as well so everybody can see you. I just want to say to our audience today, you know, I hope you can understand, I really love what I do. I love the opportunity to educate people so that you can make some empowered decisions about this area. It's my favorite area of law because you can do just that. The more knowledge that you have, you can customize your estate plan basically however you want to. And if you sort of discount the fact that you're doing it, which is that you're no longer going to be here, and you think about maybe what fun people could have with your money or how you could really support an institution that you really, really value, or an organization that you value, you can really have some fun with it, because as they say, and it is true, you can't take it with you. So Ellie, with that, let me turn this back over to you.
Thank you, Deirdre. Thank you so much, Deirdre, for your time and for sharing your expertise. If we're going to close the seminar, it is being recorded, so we hope to share that at the near future. I just want to thank everybody for your participation and for joining us today. And we hope to see you at future webinars. And thank you so much.
Thank you all. Have a lovely day. Bye-bye.